May it please the court, my name is Amber Ware, and I'm here with my co-counsel,
Daniela Nat Davis.
and we are the respondents presenting the case New York Pistol and Rifle Association. Today, we address the Supreme Court with our statement of argument. We argue that the Second Amendment does allow the government to prohibit a law-abiding person from carrying handguns outside of their home for self-defense because there needs to be probable and reasonable cause for carrying and bearing arms. Today, we will work to further support the law put forth by New York stating that there must be a special need for self-defense through the means of carrying and bearing arms. In order to support our argument, we'll be referencing the precedent of McDonald versus City of Chicago, United States versus Miller, Anderson versus Malloy, and Babinetz versus Police. We are arguing that the Second Amendment makes the clear emphasis that a well-regulated militia has the right to bear and keep arms. This does not refer to the everyday citizen because militia refers to a well-organized citizen with little military training. As the petitioner does not fit this criteria, the right does not extend. Our next point addresses strict scrutiny. We will argue that New York's penal law, section 400 to 409, specifying firearm law, was constitutional due to the compelling and substantial government interest of protecting its citizens.
Our first argument is that the court should dismiss the petitioner's claim as moot because of the specific distinction in the clarification for the Second Amendment and who it extends to. In the United States Constitution, the Second Amendment states that a well-regulated militia, being necessary to the scrutiny of a free state, the right of the people to keep and bear arms shall not be infringed. But with that being said, the most important thing that needs to be addressed is what exactly the amendment means, the limits and circumstances that apply.
What does the Second Amendment protect?
The Second Amendment protects an individual's rights to possess a firearm unconnected with service in militia, and to use that arm for traditionally lawful purposes such as self-defense within the home. The part of the Second Amendment, which includes being necessary to the scrutiny of a free state, was intended for us to defend and protect ourselves from our own government. The concealed carry license law for New York explains that in order to carry guns, a citizen must have probable cause or special need for self-protection. Many previous cases have made a distinction and clarification as to what the Second Amendment means and for who it extends to. It should be based.
Why did the framers include the Second Amendment in the Bill of Rights?
The framers included the main reason the framers included the amendment was to prevent the United States from having a standing army. Preventing the United States from starting a professional army, this was the single most important goal of the Second Amendment. They wanted the average American to be able to protect themselves without the need of an army. Also, learning from the independence from Great Britain, they did not want a tyranny nation to have complete control. They wanted civilians to have the ability to counteract and protect themselves in times when it was completely necessary. It should be based on these previous rulings that the court makes their decision. For example, the case of McDonald versus City of Chicago, the Supreme Court acknowledged in a previous case, Harlan, that individuals' rights to bear arms has its limits. It doesn't necessarily give someone the right to keep and carry weapons they choose for any purpose. It was easy for the majority to rationalize an individual owning a handgun for self-defense, but they conceded that certain individuals should not own firearms.
What are the limits of the Second Amendment's protection?
The limits of the Second Amendment of the United States Constitution reads, a well-regulated militia being necessary to the scrutiny of a free state, the right of the people to keep and bear arms shall not be infringed. Such language has created considerable debate regarding the amendment's intended scope. Guns in public are also not protected by this amendment. Those delicate places include schools, government buildings, and courts, public transportation, airports, and polling stations. The United States Court of Appeals has ruled that Article 2 of the Constitutional Amendment does not protect the public carrying of hidden weapons. Peterson versus Martinez. States can also limit where guns can be carried. Bans on weapons in schools and government buildings, for example, are allowed. So, in the terms of this case, it is completely legal for the state of New York to limit the petitioner from carrying a firearm anywhere but their home, especially since the Supreme Court case just mentioned explained and ruled that there are limits to where guns can be carried. According to the English Bill of Rights, it states that subjects which are Protestant may have arms for their defense suitable to their conditions and as allowed by law. This particularly applies to this case because the petitioner claims they did have proper reasoning and cause to get a concealed carry license.
What weapons does the term arms include?
The term arms refers collectively to offensive or defensive weapons. Arms can include guns, clubs, lead-weighted sticks, fighting knives, swords, straight razors, and any object that can be carried with the intent for defense or aggression. But if you really...
Do you understand what I'm doing? Because I thought it was in order.
But if you really analyze the reason as to why the petitioner wanted a concealed carry license, it just doesn't make sense in this context. The petitioner states that they wanted a concealed carry license because there had been a recent uptick in robberies in his neighborhood, and that he wanted to be able to defend himself with a concealed carry license. But if you look closely into the petitioner's reasoning for getting a concealed carry license, it just isn't logical. Why would you need to carry a gun out of your home if you're trying to defend yourself from home robberies? You don't need to carry a weapon anywhere other than your home when you claim the only reason you need protection is because of home robberies.
Now moving into the second main point of our argument. Historically, America has followed the same restrictions for the Second Amendment, directly relating to the fact that New York is well within its strict scrutiny rights to set policies related to the concealed carry of firearms and public laws. According to the strict scrutiny standard of judicial review,
What is strict scrutiny and intermittent scrutiny?
strict scrutiny is a form of judicial review used by its courts to determine the constitutionality of a particular law. It is often used by courts when a plaintiff sues the government for discrimination. There are things that the government will not tolerate in any shape or form. While intermediate scrutiny is, in the United States Constitution, the second level of decision-making in judicial review. The other levels are commonly referred to as the basic rational review and rigorous review. These are things that the government can decide whether something is right or not based on the situation. Standard of judicial review based on the Equal Protection Clause of the 14th Amendment. Governments may only pass legislation and certain laws to their compelling government interests. This was a policy created by the United States Supreme Court with the intent of protecting rights given by the United States Constitution. As a result, the government that wants to generate and apply the law or policy has the burden of proving the policy is constitutional. If the policy was ever presumed unconstitutional, the courts would have the responsibility to prove and rule this law unconstitutional. We approach the court today to further attest that the gun laws of the New York State law of Pinot law are constitutional and align with strict scrutiny requirements. The concealed carry laws for the New York Pinot law in sections 265.0, 204, 265.2A3, and Pinot Law 400 to Pinot Law 402F explains that in order to carry gun laws, a citizen must have probable cause or a special need for self-protection. In this case presented today, the citizen was denied this license due to the fact that they did not have sufficient enough special need for protection. As they were trying to protect themselves against robberies in their area, it did not directly correlate to a need to carry the weapon with them. Historically, the government has verified that courts have the ability to set their own laws, thus attesting to the idea that New York's concealed carry firearms laws are not an outlier. Moving on to our second sub-point. The New York law that sets restrictions on carrying concealed firearms has been confirmed to be within its constitutional right from the set of laws determined in America's history. This court has previously made the establishment that public carry laws are specific and pre-existing rights of Second Amendment. It is very important to acknowledge the long-standing history associated with gun laws and the idea that states can set their own policies on them.
How should courts determine if a gun control regulation is considered long-standing?
Courts should determine if a gun control regulation is considered long-standing if the specific regulation has been in place for a long time. A long time would be considered multiple years and had a significant impact on the country. A method of determining this factor would be referencing different precedents to observe how the gun law regulation has formed and evolved throughout the years. As it is very important to know this knowledge and the idea that states can have their own policies on them. These laws were developed from historical periods that the court identified as pre-existing rights, thus supporting the fact that they are long-standing. Dating back to medieval England times, the court used the ideals when constructing the 14th Amendment, particularly the Equal Protection Clause. This can verify the fact that New York is not the first state to create its own interpretation of the Constitution. In fact, they follow a very well-developed pattern in the United States history. Moving on to our next subpoint. Historically, the government has confirmed the state's ability to infringe on concealed carry laws. As a whole, the government has upheld restrictions on public carry laws. Throughout the country's history, carrying concealed firearms in a public space has always come with extra restrictions. There has not been a time in history where states were not given the ability to infringe upon laws and create their own stipulations surrounding gun laws. This can be referred to in the State versus Smith court case. Petitioners attest to disrupt laws and long-standing policies that result from a time period involving from founding era to the responsible cause laws of the 19th century to agneless law good cause regiments in the 20th century. Dating back to the creation of the Constitution, framers involved laws about the Second Amendment to protect their malicious right to self-defense. As a result, personal self-protection is a right given in the privacy of one's own property and shouldn't be extended to public areas. The court can attest that these are not new laws, yet long-standing. Throughout the country's history, public concealed firearm laws were created by the states to give their own restriction, and these laws have been long-standing ever since the development of the Constitution. New York's firearm laws were not just created and restricted with Pinnell laws. However, they date back to the 18th century where these laws were first in place. Moving forward to their importance today, they are still here and important because we still follow these laws and follow the president in our multiple cases.
What is the difference, if any, between the verbs keep and bear?
The difference between keep and bear means to have to retain the possession of, while bear means carrying. Essentially, referring to the location. For example, you may keep a gun in your home, but you will bear a gun when you're taking it with you to different locations. However, these laws attest to the fact that they cannot become a danger to society by taking defense in their own hand. Particularly, these laws were in place so that citizens will not endanger each other because they simply want to protect themselves. The general protection of everyone is more important than one's need for self-defense. Nonetheless, history has proven that the government has continuously taken measures to protect states' ability to set their own restrictions for concealed carrying firearm laws. This brings us to our last subpoint. New York has created these policies and laws with the intent of protecting its citizens' general population while also allowing a citizen to protect themselves as long as they are well within their rights. We approach the court today to further attest to the fact that New York's concealed carry laws were constitutional. We also attest to the fact that they are aligned with strict scrutiny laws because they were developed with New York's compelling government interest to protect their citizens. Throughout history, stipulations to protect the people have continuously been made for firearm laws, specifically concealed carry firearms.
Is there a difference between openly carrying a firearm and a concealed carrying firearm?
There actually is a very important difference between the two. Openly carrying firearm is when other people around you know that you have a firearm with you and they can clearly see the firearm. For example, if we were walking and you saw a police with his gun, you can openly see that the police is carrying his firearm. While concealed carrying a firearm is when nobody around you knows that you have the firearm with you. This could be when you're at a public location and a man is possibly hiding his gun in his jacket. No one around him will know that he has the gun unless he specifically told them. This will be the main difference between a concealed carry and a openly carry. Petitioners approached the court to argue their Second Amendment right of self-defense has been infringed upon, yet their rights have not been violated. New York is well within its rights to protect its citizens by creating restrictions that are supported by the common law of self-defense. An individual may appeal to the need to protect themselves only when intermediate of a certain immediate suffering would be the consequence of waiting for assistance of the law. This references for William Blackstone, Commentaries on the Laws of England, 184, back in 1769. Common law contemplated the implications of this law in relation to an individual's location. Eventually, it was ruled that not populated areas are more like homes where people need self-defense if attacked. However, places where individuals may get assistance to help are not extended the same gracious protection. Today, petitioners attest to the fact that though they have a license to have guns in their home, they still believe they need a license to carry guns outside their home because they do not feel protected. They argue the fact that they have been in a run-in with several different home robberies. However, the key word in this argument is home. These robberies were at home, not in a public area where they do have the opportunity to be protected by law enforcement. Places where individuals may get assistance to help are not extended the same gracious protection, referencing the argument made today. This can be seen in People v. Tomlin's case. In the Sir Matthew Hill Police of Crown, 486, 1736. Petitioners emphasize a time period where the need to protect themselves had a higher importance because they did not have law enforcement to protect them. However, they do have law enforcement to protect them. Law enforcement is readily available if they need to call 911 or any other means. They do have the means to have protection publicly. Self-defense has changed since that interpretation because there are easier means to find assistance when in trouble. And during the early times when law enforcement was in place, when these laws were in place, it was a completely different era of law enforcement. During this era, police were on foot patrol and did not have the means to travel to different situations. In the 21st century, they have phones to call in case they need help, and there are ambulances readily available to help them at any moment, and police are just a call away. This does not undermine the argument for the self-defense, but there are stipulations to the territory in which you can take self-defense into your own hands. In New York, this right is restricted to your home. The state does not also have the responsibility of ensuring the right is protected, but they have to protect the lives of the entire population in New York. As important as protecting one person is, it is also important to make sure that the vast majority are protected and that one person can endanger everyone else.
How should the court consider the public safety implications of license to carry firearms?
As I was stating, the court has to consider this as a general welfare problem. You cannot tell one person, yes, we want you to be able to protect yourself, when that one person could potentially harm a vast population of people. That one person has the ability to harm anyone around them, whether they have good intentions or not. Once you give someone a firearm, you give them lots of power, and you don't know what they're going to do with that power, even if their intentions are self-defense.
How should courts determine if a gun control regulation is considered long-standing?
A gun control regulation can be considered long-standing if that gun control regulation has been in place for a certain period of time and has been proven to be significant to the country.
And once again, Counselor, what is a militia and why did the framers refer to it in the Second Amendment?
A militia, as referenced in our argument, is a group of citizens that are not military but have been given some sort of military training and can be considered that for the reason that they're giving that little bit of training.
Back in the olden days, a militia was the citizens that needed to protect themselves in case of the British attacking them. But now, in the time that we're in, we do not need that protection. So this doesn't really apply anymore. A militia is a military force that is raised from the civilian population to supplement a regular army in an emergency. Militia, military organization of citizens with limited military training, which is available for emergency service, usually for local defense. At the time of the American Revolutionary War, militias were groups of able-bodied men who protected their own towns, colonies, and eventually states. The framers wanted at the time for civilians to be able to protect themselves from the British. But at this time, in this day and age, we do not need those type of protections since there isn't a
We would like to emphasize the fact that when these laws were in place, it was hundreds of years ago. As important as it is to uphold it in its right constitutionality, it is still important to understand the factors that went into making these laws. And one of the main factors of this militia law was the need to protect themselves against a tyrant country. Right now, we are an independent country, and the means to protect ourselves is within each other in self-defense. But we still have law enforcement that are here to help us with these goals.
In conclusion, for the reasons explained, the respondent respectfully asks the court to dismiss the petitioner's request and reinstate the district and appeals appellate court's resolution. The Second Amendment extends to the petitioner within certain boundaries. The contextualization and true definition of the word choice further assists to this claim. New York has been proven to be within its constraints of strict scrutiny to in place laws and policy directly relating to the Second Amendment, not outlying and straying away from the history of concealed carry laws, but instead aligning with it in actuality.
It is for the reasons previously stated that we pray the court keeps the decision of the New York State Rifle and Pistol Association, recognizes the Second Amendment does not allow the government to prohibit a law-abiding person from carrying handguns outside their home for self-defense and rules in favor of the respondent.
Thank you so much for listening.